23rd Amendment Act of 1992. Significance of the Act. This Act was added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provision from Article 243 to 243O. In addition, the Act has also added a new 11th schedule to the Constitution. This schedule contains 29 functional items of the Panchayat. It deals with Article 243G. The Act was given a practical shape to Article 40 of the Constitution, which says that the state shall take a step to organize village panchayat and endow them with such power and authority as may be necessary to enable them to function as units of self-government. This article forms a part of DPSP, Directive Principle of State Policy. The Act gives a constitutional stature to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligations to adopt the new Panchayati Raj system. In accordance with the provision of the Act. Consequently, neither the formation of Panchayati Raj nor the holding of elections at regular interval dependent on the will of the state government of any more. The provision of the Act can be grouped into two categories, compulsory and voluntary. Compulsory, mandatory or obligatory provision of the Act have to be included in the state's law creating the new Panchayati Raj system. The voluntary provision, on the other hand, may be included at the discretion of the state. Thus, the voluntary provision of the Act ensured the right to the state to take local factors like geographical, political, administrative, and others into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transferred the representative democracy into the participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. The Act provides for a Gram Sabha as the foundation of Panchayati Raj system. It is a body consisting of persons registered in the electoral roll of a village, comprised within the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of a Panchayat. It may exercise such power and perform such function at the village level as the legislature of the state determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate and district levels. Thus, the Act brings about uniformity in the structure of a Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakhs may not constitute the panchayats at the intermediate level. Election of members and chairpersons. All the members of panchayat at the village, intermediate and district level shall be elected directly by the people. Further, the chairperson of panchayats at the intermediate and district level shall be elected indirectly by and from amongst the elected members thereof. However, The chairperson of a panchayat at the village level shall be elected in such a manner as the state legislature determines. The chairpersons of a panchayat and other members of a panchayat elected directly or indirectly shall have the right to vote in the meeting of the panchayats. Reservation of seats. The Act provides for the reservation of the seats for scheduled caste and scheduled tribe in every panchayat, that is, at all the three levels, in proportion of their population to the total population in the panchayat area. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other level for the scheduled caste and scheduled tribes. The Act provides for the reservation of not less than one-third of the total number of seats for women, including the number of seats reserved for women belonging to scheduled caste and scheduled tribes. Further, not less than one-third of the total number of offices of chairperson in the panchayat at each level shall be reserved for women. The Act also authorizes the legislature for a state to make any provision for reservation of seat any panchayat or offices of chairperson in the panchayat at any level in favor of backward classes. The reservation of seats as well as reservation of office of chairperson in the panchayat for the scheduled caste and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 333, which is presently 70 years, that is till 2020. It must be noted here that above provision relating to the reservation of the seat in panchayat, both member and chairpersons, for the scheduled caste is not applicable to the state of Arunachal Pradesh. This is because the state is inhabited fully by the indigenous tribal people and there is no scheduled caste. This provision was added later by the 83rd Constitution Amendment Act of 2000. It means 2000. Duration of panchayats. The Act provides for a 5-year term of office to the panchayat at every level. However, it can be dissolved before the completion of its term. Further, fresh election to the constituent of panchayat shall be completed before the expiry of its duration of 5 years. In case of dissolution before the expiry of a period of 6 months from the date of its dissolution. But where the remainder of the period for which is the dissolved panchayat would have continued is less than 6 months, it shall not be necessary to hold any election for constituting the new panchayat for such period. Moreover, the panchayat constituted upon the dissolution of a panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panchayat would have continued had it not been so dissolved. In other words, a panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years, but remain in the office only for the remainder of the period. Disqualification. A person shall be disqualified for being chosen as or for being a member of panchayat if he is so disqualified under any law. A. Under any law for the time of being in the force or for the purpose election to the legislature of the state concerned. B. Under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of the age if he is attained the age of 21 years. Further, all question of disqualification shall be referred to such authority as the state legislative determines. State Election Commission. The superintendence or direction and control of the preparation of the electoral roll and conduct of all election or to the panchayat shall be vested in the State Election Commission. It consists of a state election commissioner to be appointed by the governor. He is condition of service and tenure of office shall also be determined by the governor. He shall not be removed from the office except in the manner or on the ground prescribed for the removal of the judge of the state high court. His condition of the service shall not be varied and his disadvantage after his appointment. The state legislature may make a provision with respect to all matter relating to the election to the panchayats, power and functions. The state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions to self-government. Such a scheme may contain provision for the devolution of powers and responsibility upon panchayats at the appropriate level with respect to the preparation of a plan for the economic development and social justice, the implementation of the scheme for economic development and social justice as may be entrusted to them, including those in the relation to the matter listed in the 11th schedule. Finance. The state legislature may a. Authority of panchayat to leave, collect and appropriate the taxes, duties, tolls and fees. B. Assign to panchayat taxes, duties, tolls and fee levied and collected by the state government. C. Provide for making grant in aid to the panchayat from the consolidated fund of the state. D. Provide for the constitution of funds or for crediting all monies of the panchayats. Finance Commission. The governor of a state shall after every 5 years constitute a finance commission to review the financial position of the panchayat. It shall make the following recommendation to the government. First, the principle that should govern A. The distribution between the state and panchayat of the net proceed, the taxes, duties, toll and fees levied by the state and allocation of a share among the panchayat at all levels. Determination B. The determination of taxes, duties, tolls and fees that may be assigned to the panchayats. C. The grants in aid to the panchayat from the consolidated fund to the state. Second, the measure needed to improve the financial position of the panchayat. Third, any other matter referred to it by the governor in the interest of the sound finance of the panchayats. The state legislature may provide for the composition of the commission, the required qualification of its member and the governor of their selection. The governor shall place the recommendation of the commission along with the action taken reports before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state so supplement the resource of panchayats in the state on the basis of the recommendation made by the Finance Commission of the state. Audit of account. The state legislature may make the provision with respect to the maintenance of account by the panchayats and the auditing of such account. Application of union territories. The provision of these parts are applicable or to the union territories, but the president may direct that they would apply to a union territory subject to such exception and modification as he may specify. Exempted state and areas. The Act does not apply to the state of Nagaland, Meghalaya and Mizoram and certain other areas. These areas including A. The scheduled areas and the tribal areas in the state. B. The hill areas of the Manipur for which district councils exist. Darjeeling districts of West Bengal for which Darjeeling Gorkha Hills Council exists. However, Parliament may extend the provision of this part to the scheduled areas, tribal areas subject to such exception and modification as it may specify. Under this provision, the Parliament has enacted the provision of the Panchayat Extension to the Scheduled Areas Act 1996, properly known as PESA, PESA Act of the or Extension Act. Continuance of existing law and panchayat. All the state law relating to panchayat shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the state have to adopt the new Panchayati Raj system based on his act within the maximum period of 1 year from 24 April 1993, which was the date of the commencement of this act. However, all the panchayats existing immediately before the commencement of act shall continue till the expiry of their terms, unless dissolved by the state legislature sooner. Consequently, majority of the state passed the Panchayati Raj Act in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Bar of interference by the court in electoral matter. The act bars of the interference by the court in the electoral matter of the panchayat. It declares that the validity of any law relating to the delimitation of constituencies or allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election or to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 11th schedule. It contains the following 29 functional items placed within the purview of panchayat. First, agriculture including agriculture extension. Second, land improvement, implementation of land reform, land consolidation and consolidation and soil conservation. Third, minor irrigation, water management or watershed development. Fourth, animal husbandry, dairying and poultry. 5. Fishes. 6. Social forestry and farm forestry. 7th, minor forest produce. 8. Small scale industries including food processing industries. 9. Khadi, village and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways and other means of communication. 14. Rural electrification including distribution of electricity. 15. Non-conventional energy source. 16. Poverty alleviation program. 17. Education including the primary and secondary school. 18. Technical training and vocational education. 19. Adult and non-formal education. 20. Libraries. 21. Cultural activity. 22. Market and fair. 23. Health and sanitation including hospital, primary health center and dispensaries. 24. Family welfare. 25. Women and child development. 26. Social welfare including welfare of the handicapped and mentally retarded. 27. Welfare of the weaker section and in particular of the scheduled caste and scheduled tribes. 28. Public distribution system. 29. Maintenance of community assist. Thank you.